Hello, and welcome back to Coin Lady channel. In the SEC vs Ripple case, Judge Analisa Torres ruled that XRP itself is not a security because, and I'm paraphrasing here, she said that XRP does not embody the requirements of the Howey test. By now, many of you have undoubtedly heard that a judge has come out strongly against Judge Torres. Therefore, it was clearly not a security. Intellectually, I don't believe he did such a hot job here. And there's a different lawsuit in which a judge just verbally ripped Judge Torres' position to shreds. Well, now that I've had some time to let this information settle, and after hearing the other side of the argument from attorney John Deaton, I have a better grasp on the situation. In this video, I interview attorney James Murphy, whose thoughts on the matter I find really intriguing. I'll show you the specifics of his accusation that this judge is a renegade from some months ago. But he labeled this judge a renegade judge and said, mind you, the judge that said would you know what he said, it was a few months ago or so. His judicial district is overseen by Judge Torres. Before the SEC vs Ripple case came to a close, he noted this one judge who frequently rules in opposition to the district's other judges. Simply put, he follows this pattern that Murphy's lawyer noticed. That person made those accusations against Torres. It's as if he'd rather have the contrary view than argue the interesting points being made. This is the one judge on whom I can rely, as I have already heard commentary from Ripple's top in-house attorney and steward. But before we go any further, let me make it perfectly obvious that I have zero expertise in either law or finance. I am not qualified to give you financial or legal counsel. And you know that you shouldn't make any financial decisions based on what I say, right? For fun and as a pastime, I enjoy making videos about crypto-related topics to share on YouTube. And so, despite all this craziness, I didn't know it in a video I uploaded yesterday. And yet, the Bitcoin maximalists seem to like this discussion. Nothing at all is altered by this. The verdict of Judge Torres is final and binding. Even more so, XRP is not a security. The blockchain advocate said the following on X, previously Twitter, this morning, and I think he said it fairly well. Despite their best efforts, XRP is listed everywhere and is not a security. Blockchain supporters are afraid, but there are still haters out there. There are also those who will always defend the SEC, no matter what arguments are made against it. For example, here is former SEC attorney John Reed Stark. I'm scrolling down to show you a tweet, or post, as they're called these days, that he sent out. Feel free to pause me while I proceed down the page if you want to read this whole thing. But I'm just saying that a lot of people seem to be interested in this. And it doesn't alter the outcome one bit. To put it simply, XRP is not a security. And this judge has the erroneous opinion on this particular subject, yet, the extent to which this judge is stating the wrong stuff is fairly debatable, as we will see. There was already an intriguing perspective on that from some steward. Now consider this. The Bitcoin Signal is the name of one of the user accounts on this site. They further claimed that the judgment against XRP being a security in the secondary market was incorrect. And that was one of those Twitter spaces, now known as X Spaces, I guess, where individuals can come and publicly speak in real time, and attorney John Deaton retweeted it. The post was shared by attorney Dean, who added the following comment. This is what we refer to as either complete gaslighting or a complete inability to understand legal precedent. The judge never explicitly stated that secondary market sales do not constitute securities, she just stipulated what must be done when determining if there is a positive investment, contract, transaction, or scheme. You must apply the Howey factors to each transaction of the asset. I've said that on this channel, and attorney Deaton explains why, but I've also thought about it. And I figured, okay, I try to be as precise as possible with my words, but I'm only human. So, naturally, we're not perfect, but I think I can point to one area where we succeed. Sometimes I have described a certain concept by saying that secondary market transactions are not illegal securities transactions, and I believe that in the future I could be more clear in doing so. The point I was making is that they aren't inherently illegal securities transactions, but I have documented that they can in some cases since you can still have an investment contract. Nothing about secondary market transactions, for instance, automatically binds us as XRP holders or buyers or other secondary markets to Ripple, even if we assume that XRP and Ripple are related in some way. I meant to convey precisely that point. But I always aim to be as detailed as possible, so we can work on that. Therefore, something has no inherent meaning. However, it is still possible for any individual transaction involving any underlying asset to be part of a scheme, which would make the transaction illegal, even if it takes place in the secondary market. Right. I am aware that I have said this before, but there are moments when I convince myself that I simply cannot follow through. And I think that describes a good portion of us. Many of us in the community, I believe, have been operating in this fashion. So, I thought I'd mention it so that we may all make an effort to be more precise. This is the ultimate goal of my life. But I don't want to stray too far from the topic at hand. But then, Attorney Deaton said, the correct answer under the law is a token sold in the secondary market off an exchange, could be an investment contract. You don't know until you apply the Howey factors to the circumstances surrounding the sale. To illustrate, Judge Torres used a secondary sale of the Howey orange groves as an example, where the second purchaser bought not from Howey, but from the first purchaser, and was completely unaware of the Howey company. During the second sale, all that was said was, "Do you want to buy my acre of orange groves?" And the second buyer agreed, saying he intended to cultivate and sell the oranges himself. Obviously, this is not a contract for investing. That's the same idea that most first-time XRP holders have, guys. They were first-time buyers who were unaware about XRP. That wave, or rather, was real. It's not out of the ordinary for an American firm to experience such a tremor. Almost all XRP purchases, including brand new ones, are being sent to countries outside the US. It's not surprising that they are unaware of this firm situated in the United States. Nothing at all has been taught to them in that regard. In a similar vein, the Supreme Court held in 1946 that purchasing this orange grove constitutes participation in an unlawful investment scheme. You're not engaging in an illegal securities transaction if you buy that, which was included in that, and even though you don't know W.J. Howey coexists, the same goes for XRP. However, there are secondary market transactions that are legal. And so the attorney says, on the other hand, if the first buyer tells the second buyer, buy this orange grove in the house, the company will do all the work. And the reason you're seeing so much fun is because, first of all, it's coming from the crazy former SEC attorney, who is pretty much some of them crazy anyway, though not all of them, and then the Bitcoin maxis, who are, frankly, responsible for the vast majority of the hilarity. And so we see all this fear, uncertainty, and doubt, but it's because they hate this. They're just a problem because some people are undoubtedly feeling some shame for being wrong about this, but they still want to keep promoting their story regardless of the evidence. They wish for their desired truth to be true. True, reality is a banana. And now look at this, this is awesome. James Murphy, the lawyer better known as X's metal lawman, is a renegade judge. And this tape is from he said, your 7 months ago, which was on Brad Kime's YouTube channel. And it just lasts for around 36 seconds, but all you need to know is that he made a warning about this judge, John Ray Koff, 7 months ago. His first name is probably John or John Ray. He further explained that this judge serves in the same jurisdiction as Judge Torres. Additionally, he prefers to rule against other judges in the same district. He also mentioned that he used to practice there and claimed that the only reason he is able to communicate this is because he no longer does so. However, he has previously worked in the New York area. I found it amusing that he would reference a judge sitting in the same courtroom as another judge in the same building. He just doesn't seem interested in practicing anymore. So, I'll just come out and say it, Judge Rakoff has a penchant for finding fault with everything. So now I'm wondering if he's the type who'll agree to anything for the sake of a buck, or if he's just an argumentative jerk who enjoys telling others they're wrong, instead of, doing the proper and true thing. That is really concerning. However, not every judge is competent. We should count our blessings that this army has judge deployments. What follows is what Attorney Murphy wrote while posting that video. Yesterday, Judge Rakoff issued an opinion rejecting Judge Torres's consequential ruling. Obviously, this is the case. Several months ago, I singled out Rakoff as the judge on my bench who was most willing to disagree with another judge. I should also pause to mention that even though Attorney Deaton acknowledged the possibility of a court in the same district disagreeing with vacationers, he still represented them. In most cases, courts won't rule in your favor. I mean, it kind of solves some questions to some degree. Doesn't know what you believe, given that this renegade judge has been noted prior to the ruling. It's still true, though, that courts aren't likely to rule against judicial tours. Obviously, everything is possible. The unexpected occurred. But that doesn't make him right in any way. Then a character with the initials D entered the picture. K emailed James Murphy, Attorney Murphy, saying he did not disagree but that Murphy could present the situation in any light he saw fit. Storytelling is crucial. Well, Attorney Murphy disagrees with you there. According to him, the judge did rule against them. Attorney Murphy wrote, "Yes, I read that as a disagreement," referencing a passage from Judge Rake's opinion that reads, "The court," which means Rakoff rejects the approach recently adopted by another judge of the district, in a similar case, SEC versus Ripple Labs Incorporated. That, by definition, is an argument against the statement. However, this may not imply that things are indeed as dire as they seemed at first. Okay, thanks to Stewart, I now see things from his point of view. Hello, I'm the head attorney for Ripple. 2 strands, both of which are extremely brief. 3 tweets are shared by both of them. It's 3 tweets for the first one. Dated yesterday. Then, not long after that, this news came out. These are just some quick thoughts. Having given the matter some more thought and consideration this morning, Stewart reached a different conclusion after rereading the same facts. Since I have made my film on the subject, I thought I'd share the initial feedback from yesterday. So far, I haven't heard anything about this. There seems to be some uncertainty, so let me set the record straight, Stewart wrote. The conclusion that XRP is not a security has not changed as a result of the decision in the Terra case. The judge in the Terra case must also assume, for the time being, that the SEC's allegations are true. Our decision was reached after the court reviewed a comprehensive factual record compiled over 2 years. As for Terra judge's apparent misreading of the judge's Ripple judgment, I'll let others delve into that. Forgetting that, say, I accidentally drank a little water is a good example. I'm truly sorry. That's okay. Good news. I'll let others explore that area, he says. He seems to have misunderstood the Ripple judge's logic, among other things. If buyers in the secondary market don't know who they're buying from, they can't risk their money on anything. That makes perfect sense. But he had some more ideas to share. Look at this, then. Only a few hours ago, he retweeted his own topic. After a second look, his writing became clear. The judge agrees that uncultivated orange groves with no agreements to share the income are not securities. An investment contract requires an understanding between the parties involved. If a token is issued without any accompanying rights or commitments, it cannot be considered a security. The remark regarding the Ripple ruling is vague and non-binding. And there you have it, the most crucial part, it's not legally binding, it's simply what this guy said, and it's his opinion. Totally irrelevant. When it came to our case, he wasn't the judge. We lucked out and didn't end up with that guy. Sounds like the rogue judge we warned you about is a real piece of work. Unfortunately, I missed that video. If you hadn't seen that video 7 months ago, you now know that Attorney Murphy was warning about this. I didn't watch that video, but it's fascinating to know that a warning was put out there. And wouldn't you know it, that judge is the only one who has publicly opposed Judge Torres for the same absurd reasons. So, Stuart Otter, I've already mentioned that there's no need for this. There's a lot of ambiguity. It's easy to confuse Bitcoin Maximus with Bitcoin. That's what's making things even more complicated. It's making things worse. To be honest, I don't think many of them are very bright. But you know, there are a bunch of ignorant knuckle-dragging, mouth-breathing troglodytes with cashew-sized brains who can't put on their own damn clothes in the morning and who wear Velcro shoes because that's the only way they're going to get shoes on by themselves. No doubt about it. People are spending several days waiting to cross a bridge that requires payment in Bitcoin at peak traffic hours by staying warm under a garbage fire. Because of this, you shouldn't anticipate them to be involved in deep philosophical discussions. That's what you'd expect to see, sure. And what we're witnessing now is that people are terrible, horrible trolls. I think a lot of those Bitcoin maxi trolls are being dishonest even if they did figure it out. They are ideologues who only want to believe what they already believe, and they live in an echo chamber. And since they are awful liars, they will make claims they know to be false. Now we're done. I just want to believe whatever is true and live in a world full of reality, and these folks aren't assisting me with that. This truly gets under my skin, people. Since I'm not a certified financial planner, you shouldn't use my advice to make any investments or trades. Please like and subscribe my channel. See you later, bye.